Okay, welcome everybody to our Posthumanism Research Institute event. This is a talk today by Dr. Emily Jones from the University of Essex, where she's a senior lecturer in law and human rights. The talk today is Posthuman International Law and the Rights of Nature. Our speaker, as I said, is a senior lecturer in the School of Law and Human Rights Center at the University of Essex. Emily is a generalist public international lawyer whose interdisciplinary work combines theory and practice. Her work cuts across posthuman legal theory, gender and international law, international environmental law, the law of the sea, science, technology and international law, gender and conflict, and political economy, imperialism, and international law. A whole bunch of really interesting, fascinating topics and subfields. So without further ado, Emily, the floor is yours. Just a comment for our attendees, welcome. There will be a Q&A session after the talk. Please use the Q&A button at the bottom of your screen to ask your question. And we will be posting a recording of this talk on the YouTube channel in the next few days. Only the talk portion of the event will be available on the YouTube channel. So Emily, please.
Thank you so much, Christine, and it's really wonderful to be here. I'm a big fan of the Posthuman Research Institute, so I was delighted to be invited. And thank you so much to the participants in the audience. I recognise quite a few of the names, but there's a few new people there as well, which is always quite exciting. So as Christine mentioned, the title of my paper today is Posthuman International Law and the Rights of Nature, and I've prepared around 40 minutes to speak for, because that's what I was asked to do. So really, this paper starts off on the premise that international environmental law is very anthropocentric, that it tends to prioritize human interests and quite often human economic interests over all others. And my kind of interest in this then came about through thinking, well, you know, posthuman theory for me is, you know, seeks to challenge anthropocentrism. So what can that add to thinking about international environmental law? But then I was also, you know, kind of doing some more research on this, and this was actually a few years ago. This research started when I was still doing my PhD, and you know, I started seeing lots of things in the news about the rights of nature. So, you know, a kind of river gaining rights in New Zealand, forest, etc. And I thought, well, that also, you know, the kind of rights of non-humans. There's something sort of inherently slightly posthuman about that. Potentially. I mean, obviously there are kind of limitations too that I'll talk about, but that's kind of where my interest came. How can these things be kind of brought together? How can posthuman theory really inform rights of nature, and how can this be used to rethink international environmental law? I guess my other interest in this is thinking about practice, and I know Christine, alongside others, has a new series actually out with Bloomsbury that's looking at posthumanism and in practice, and that's something I'm really interested in. How can we, you know, a lot of posthuman theory is very, very deeply theoretical. And there's often that link to the real world, but it's not being applied so much actually in practice. And I think that that's really going to be the next step. So that's why I'm very excited about Christine's series, but it's also really where I want my work to go. But in terms of rights of nature, and as I'll discuss in this talk, they've mostly been applied in domestic law, so in different countries, but they haven't really been applied in international law. So that's one thing that I want to work on. How can we bring this to international law as an international lawyer myself? But also the question of what the rights of nature is, what it includes and excludes, also remains very contested. So that's something else that I will explore in this paper. How can posthuman theory inform the rights of nature, as these rights are still kind of being formulated themselves? So a very quick note on how I'm defining the posthuman here, and I'm not going to spend so long on outlining posthuman theory in this talk. I'll do it a bit more briefly than I would otherwise, because I think it's probably the element of my paper that this audience is most familiar with. But the type of posthuman theory that I'm most interested in is very much critical posthuman scholarship. So scholars that I'm very interested in would be, of course, Christine's work, Rosie Braidotti, Jane Bennett, Stacey Alamo, Karen Barrard, etc. So I'm defining the post-human here as both challenging humanism and the inequalities between humans. So I think the kind of history and links between kind of race, critical race theory, gender studies, queer theory, disability, etc., is really important here. But also challenging the idea that the human sits in hierarchy over all other subjects, including non-human animals and, of course, the environment. So that's how I'm using post-human theory. And as I said, I'll talk a little bit more about the specific elements that I'm going to use later on. But on another note, thinking about the rights of nature, rights of nature have now been recognized in over 27 countries. But the other thing that I really wanted to note here is that Indigenous peoples have played a central role in ensuring the recognition of the rights of nature in many of these instances. And while post-human theories and some strands of Indigenous thought have commonalities, and I think the work of Simone Bignall is particularly interesting here and some of her colleagues in Australia, there are also a lot of divergences. And it's also really important to note that not all Indigenous peoples actually support a rights of nature approach. So some Australian nations in particular have said that they don't agree with the concept of rights. They call instead for a caring for country approach. And while much more work needs to be done to bring kind of Indigenous perspectives and post-human thought together, noting the differences and convergences, this isn't really what this paper is about. So I kind of wanted to just preempt that from the start. It kind of is beyond the scope of what I've done so far, but hopefully there's more work to be done there in the future. So to start off on the kind of main body of the paper, I want to start off with the law. So thinking about, well, why do I say that international environmental law is anthropocentric, and what are the problems that I'm trying to address? So international environmental law, for the non-lawyers, and I know there are a few lawyers in the audience as well, so I'll try and make this interesting for both, which is quite a challenge, but it's made up of a series of focused instruments that govern different parts of the environment in very different ways. So we'll have a focus on biodiversity in one section, or the obligation to preserve the marine environment, or a treaty to decrease pollution. So my point here is that it's very fragmented. There are kind of different rules, different principles, different levels of protection according to the environment or the specific thing that we're talking about. And there is no general obligation in international law to protect the environment. I mean, there are emerging calls that there should be a wider obligation, but largely it's agreed that we're not quite there yet. And there are kind of some efforts to unify this. I've said it's very fragmented. It's in lots of different parts. So, there are ongoing negotiations to create a global pact for the environment, for example, which would consolidate existing principles. But the problem with this is that ultimately it's about consolidating the existing law. And my argument is that actually that law is already pretty anthropocentric. It prioritizes state interests and primarily economic interests over others. So, there's only so far that something like the Global Pact can go from this perspective. There have been kind of other moves to protect the environment in a more holistic way, particularly through human rights law. And human rights in the environment is one of the kind of most interesting and increasingly emerging areas of environmental law. And human rights in the environment cover many different things. The issue of environmental refugees, environmental impact of conflict, etc. But one kind of very promising area is actually the human right to a healthy environment. And this right was actually recognized internationally for the first time at the Human Rights Council only a few weeks ago. The right includes lots of different elements. So the right to breathe clean air, have access to clean water, healthy and sustainable food, a safe climate, etc. And while that's really great, it encompasses many elements and that's really promising, it remains limited in the way it is framed. After all, anthropocentrism is central to human rights. The right to a healthy environment is a human right, and therefore it's about the rights of humans to a healthy environment. This means that environmental damage that doesn't at first glance impact upon humans, or environmental damage that actually happens far away. So where there aren't human occupants, so the high seas, for example, international territory that's very far away from most humans, is not going to be addressed by this right in its current framing. So ultimately, while this is really a promising kind of focal point in the law, I'm trying to argue that international law remains very anthropocentric. It still primarily focuses on human concerns. And this ultimately means that international environmental law reproduces a problematic subject-object binary, which the humans are the central subject of the law, and the environment is rendered as an object. So we can even see this in the principle of sustainable development. This is the principle that says, well, actually, you can develop, you can use the environment, and you can, use the natural resources, but it has to be in a sustainable way. But that's still kind of allowing for development to be part of the discourse. So the environment is always limited by the fact that humans might need it. So this kind of paradigm shift, has led scholars such as Anna Greer to ask whether environmental law can actually respond to alternative modes of knowing and coordination. And to quote, she asks, can environmental law respect multiple forms of sharing the world? End quote. It's very clear from this brief overview through international environmental law. I hope that it's clear. It's obviously a bit brief, but I think it clearly has a long way to go. But scholars such as Anna Greer and myself have begun to draw on posthuman and new materialist theory to seek to answer the question of whether international environmental law, or environmental law in general, can move beyond its anthropocentric structures. So moving on to thinking about posthuman theory, and I said I will keep this section a bit kind of more brief, but I'm happy to answer questions afterwards if you want me to expand, but I'm aware that this audience is kind of more of a posthuman audience, which is very cool. So, but posthuman legal theory in particular has actually expanded as an area of research over the past few years. There's lots of scholarship here, and it focuses on various issues. So you have Janneke Karl's work on posthuman data, my work and Matilda Arvidsson's on military technologies. And then of course, increasingly, we're seeing work on environmental law. So you have Marie Posthuman, myself, Anna Greer, etc. But whilst this kind of legal scholarship has been really successful in challenging the humanism and anthropocentrism of legal frameworks, as legal theorist Margaret Davies notes, the next step really in posthuman legal approaches is going to be moving from theory to practice. So in response to this challenge posed by Davies, this is what I'm really interested in. How can posthuman theory be applied to foster legal change? And here, of course, I'm focusing on international environmental law. But before I kind of get to the application, I should probably provide a bit of an outline of some of the posthuman ideas that I think are particularly relevant in this area. So as I said, posthuman theory, I'm defining as kind of seeking to move beyond humanism, so the inequalities between humans, and anthropocentrism, the idea that the human is the central subject of thought. Posthuman theories broadly call for an account of subjectivity that thinks about non-human entities as well, including a better understanding of agency and the agency of matter. So posthuman theory is, of course, a very vast and varied field, but I guess what I'm primarily interested in here, just because of the nature of the topic, environmental law, are posthuman theories of new materialism. Here I'm defining new materialism as part of the posthuman convergence. Some people see it as slightly different, but I see it as very much part and use it as part of the posthuman convergence between post-anthropocentrism and posthumanism. And new materialism broadly seeks to resituate the importance of matter in Western thought. So it does lie more squarely within post-anthropocentrism. But I think it's really important to draw on new materialism within the wider frame of posthuman theory, because that really ensures that, while we're focusing on, the agency of matter and challenging subject-object binaries, it ensures that those critiques of humanism are not lost. So, we retain the insights from, post-colonial theory, gender theory, queer theory, etc. So I think leaning into post-human theory and seeing new materialist theory as part of that avoids the risk that actually some new materialist theory has been critiqued for. So, there have been critiques of new materialist theory that say that in seeking to recenter ontology, so the kind of matter, etc., epistemology is sometimes sidelined. So there's so much focus on matter that we forget the inequalities in the world. And that's not something that I want to do. I come from a kind of gender studies background, gender and law. So I'm very interested in, ensuring that those inequalities in the world are very much read into my theory, even if I am focusing on matter. So what I'm therefore terming post-human theories of new materialism, that's kind of the way that I'm framing this, include a broad range of theories. So we have the works such as of Jane Bennett on vibrant matter. We have the term onto-epistemology and agential realism, which is often associated with Karen Barad. Or Rosie Braidotti uses the term vitalist materialism. I'm not going to spend loads of time going into the details of all of these different theories and what they actually say. I kind of just want to outline some of the core elements for the purposes of this paper. So broadly, these theories challenge the kind of understandings of subjectivity that are dominant in Western thought, stressing the force of living matter itself and the ways in which nature culture has already been long complicated by techno-scientific discovery. For example, Jane Bennett, in her work on vibrant matter, challenges the binding of subjectivity to the fantasy of human uniqueness, and to quote her, the fantasy that we are really in charge of those its, end quote. Bennett thereby characterizes matter as an actant, challenge the idea that objects are the opposite to subjects through a focus on thing power. Humans impact upon and are impacted by things, yet humans are also, and again to quote Bennett, a particularly potent mix of minerals, end quote. So post-human theory and Bennett's work, among others, challenges the idea that agency is something held by humans alone, but rather states that there is a kind of agency is always a human, non-human working group. Challenging the centrality of humans as subject and matter being therefore object is vital. And we can already imagine why this would be important for environmental law, because this has long justified environmental exploitation. In turn, this would allow, a post-human approach allows, I argue, for a kind of more adequate understanding of the way non-human powers circulate in the world. And allows us to challenge this idea that the environment is always object by seeing it and matter as itself alive, as a subject too. So under these theories, humans and non-humans are situated in co-emergent relationalities. So agency is never pure or absolute under this frame, but always distributed. This, however, is a world where, as Donna Haraway writes, to quote, nothing is connected to everything, everything is connected to something, end quote. The repercussions of such relationalities directly challenge international environmental laws, imagined separation of humans, non-humans, and environments into separate legal spheres. So as I mentioned at the start, we have human rights in the environment that's focusing on human needs. We might have a treaty, we have a convention on biodiversity, and that focuses particularly on that area. These kind of separations are something as well that post-human theory would challenge. We need to see these things as more interconnected. So it's clear that post-human theory can have potentially radical implications for international environmental law. But this brings me on to the rights of nature. So I'm interested in applying these theories to the rights of nature, but of course I need to first tell you a little bit about what the rights of nature are at this stage. Over the past few decades, nature has begun to be recognized both as having rights and as being a legal person in certain contexts. Rights of nature laws are, as Craig Kaufman and Linda Sheehan argue, to quote, emerging in response to extreme pressure on ecosystems and on communities that live and rely on them, end quote. The call for the environment to have legal rights and or personhood, allowing it to bring claims in law on behalf of itself, could challenge the anthropocentrism of international environmental law. And we could already begin to think through some of the links here with post-human theory. So, rights of nature laws directly challenge the idea that humans are separate from nature and that nature is an object to be exploited for human economic needs, because nature here is being made a subject in some form. So allowing nature as an actor and seeing nature as a kind of connected ecosystem that encompasses multiple human and non-human interests could, I argue, through this rights of nature paradigm, if then applied to international environmental law, be really important. But of course, this will depend on how the rights of nature are defined. So I said at the start, rights of nature is still a kind of emerging issue. It's emerging in multiple domestic contexts, but there's a lot of debate as to what they should include, exclude, and different provisions exist that are, very, very different to one another. So there's a lot of work to be done here. So as I noted, these rights of nature have been recognised in a variety of domestic contexts, and there have been some pushes for international recognition of the rights of nature. So for example, in 2009, the Bolivian president called on the UN General Assembly to adopt a universal declaration on the rights of Mother Earth. And a year later, Bolivia then hosted the World People's Conference on Climate Change and the Rights of Mother Earth, where a citizens' universal declaration on the rights of Mother Earth was then written. The text asserts the rights of nature, which includes the role humans play and pays particular attention to the multiple power dynamics which structure the climate change debate, calling as well for the decolonisation of the atmosphere. But there have also been other kind of UN level talks. There are annual intergovernmental negotiations that have been held since 2009 on constructing a non-anthropocentric understanding of sustainable development. And there are lots of UN General Assembly resolutions and reports that call for wider recognition of the rights of nature. There's also a series of UN General Assembly interactive dialogues that have been held through what is known as the Harmony with Nature programme. So, there have been a lot of kind of calls for these rights to be recognised in international law, but they haven't yet been actually recognised. Importantly, there's the citizen-led International Tribunal for the Rights of Nature. So that's not a kind of official UN thing. It's something that's created by civil society. And they've been kind of putting forward citizen-led cases on applying a rights of nature approach. So that's really useful when thinking about jurisprudence here. But despite that, overall, what we can see is that, rights of nature have been little considered in international law. So to understand what the rights of nature may include or exclude, we need to look at domestic law. As I noted above, Indigenous peoples have been central in obtaining the rights of nature in various contexts. So I'm going to go through a couple of core elements in domestic law here, thinking about what are some of the key provisions, some of the similarities and differences. And the role Indigenous peoples have played is something that is very vital in this area. So, for example, Indigenous peoples played a key role in the recognition of the rights of nature in Ecuador's 2008 constitution. The constitution celebrates nature, with nature being defined as Pachamama, referring, of course, to the sacred deity revered by Indigenous peoples in the Andes. In New Zealand, too, Indigenous peoples have also played a central role in the recognition of the rights of nature. Here, the rights of nature were recognised via 2 agreements, which came about following long negotiation processes with local Maori activists. However, as I've noted, Indigenous people have not been involved in all instances of rights of nature recognition. For example, they have not been involved in the proposed Rights of Nature Bill, which is still going through Parliament in the Philippines, nor of the recognition of the rights of nature in India, which was actually subsequently overruled by the Supreme Court, but at one point it was recognised. But it's clear that Indigenous legalities, despite not always being involved in all of these domestic examples, have played a central role in the recasting of legal concepts that has led to the emergence of the recognition of the rights of nature. So I already mentioned Ecuador has recognised the rights of nature, and actually in 2008, Ecuador was the first country to recognise the rights of nature at a constitutional level. So I mentioned, that Ecuador recognises the rights of nature as being inherent to the earth itself. And this legal recognition and status applies nationally, so across the whole country. This very broad national coverage, however, differs from other rights of nature provisions, which tend to focus more on specific ecosystems. So, for example, if we look to New Zealand, the Wangani River and the Te Uera Forest have had their legal personality recognised. Here, however, the relevant laws define the boundaries of the two ecosystems. So the law actually says, where the boundaries are. And therefore, legal personality is only recognised in those specific areas, so not across the entirety of New Zealand. The latter is a more common approach to the application of rights of nature in domestic law. And of course, from a posthuman perspective, there are problems with this. Recognising rights of nature within a bounded area alone risks perpetuating this fragmented idea of the law, separating ecosystems off one another. Okay, this river has legal personality, but the rest, everything it connects to doesn't. This is kind of a problem I already identified with the law as it is. So arguably the type of agency and connection that posthuman theory calls for would need kind of global recognition. And recognising the rights of nature within a bounded area alone potentially denies these interconnections beyond these boundaries. Rights of nature provisions also differ quite a lot in their content, but they do share at least one key commonality, and that is the linking of the health and well-being of the environment to that of the people who live there, such as the provisions allow people to bring legal claims on behalf of nature. So, for example, in coming to one of the agreements in New Zealand, the Wangari Iwi argued that they are connected to the environment they live in and that the river is alive, an ancestor. The Act therefore recognises the river as a legal person with, to quote the Act, all the rights, powers, duties and liabilities of a legal person, end quote. To uphold the river's interests, a guardian body must be appointed and it is authorised to speak on behalf of the river. And the body is made up of one Maori representative and one Crown representative. The river and the people in the Act are therefore deemed to be inseparable, meaning that harming the river is, by law, harming the people. Similarly, in Ecuador, the Constitution states that humans are an inherent part of nature, and rights of nature is actually linked to the right to a healthy environment here. Article 71 of the Constitution states, to quote, that all persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature, end quote. In the US, where actually there are lots of, at the state level, there have been a lot of kind of recognitions of the rights of nature. There are now well over 40 such provisions in local laws. These provisions also tend to link local communities to nature. And this is also primarily because actually a lot of this has grown through the work of local environmental activists. So the focus on community or people's rights within rights of nature could be seen as a very human-centered approach. And you could argue that this is not really very post-human. But of course, post-human theory doesn't suggest that we should displace culture for or by nature, but rather ask for us to focus on the nature-culture continuum. By drawing out the entanglements between humans, non-humans, and the environment, a more reciprocal dynamic can be made central for the law. Whether rights of nature approaches are always achieving this is left open. A lot of these provisions have yet to really be applied. They might be on the books, but we haven't seen too much case law. So we'll have to kind of see how it works. So as I mentioned, rights of nature approaches have been applied through different means and different contexts. And another clear division is the different models that recognise rights on the one hand, as in Ecuador, and legal personality models, such as in New Zealand. A legal personality model was used. So this kind of makes the environment, or here the river and the forest, legal people to access the New Zealand's legal system. And this was done because actually the Maori people who were negotiating did not want to emphasize the concept of rights, because to them, nature is not property, but is a living spiritual entity, an ancestor. So therefore, they wanted to promote guardianship over the idea of rights. They weren't happy with the term rights. This therefore explains some of the differences with, say, for example, the provisions put forward in Ecuador. And the different models actually do result in very different procedures. So unlike Ecuador's rights of nature laws, New Zealand laws do not award inherent rights. It's not like nature has rights and it's, you know, across the whole country, but rather the legal personality is instilled on the river and the forest. This grants them, through their guardians, procedural access rights in New Zealand's legal system, but it doesn't necessarily give them special rights. These systems, therefore, under this legal personality model, have the mediated right to petition the court or to receive reparations, but don't necessarily have the right to be protected in and of themselves. And this also matters in terms of what happens when rights of nature clash with other rights. You know, rights are always clashing all the time, and that it's up to courts often to balance these. And here we can turn to Ecuador to look for some of the kind of ways in which this has been dealt with, because Ecuador, being one of the first states to recognize the rights of nature, has some of the most highly developed jurisprudence in this area. So, as I mentioned, in the Constitution of Ecuador, the rights of nature is provided for in the Constitution across the whole state. And it's stated that, to quote the Constitution, the state shall apply preventative and restrictive measures on activities that might lead to the extinction of species, the destruction of ecosystems, and the permanent alteration of natural cycles, end quote. However, nature rights are not absolutely protected. So, for example, the Constitution notes that they have to be balanced against development needs, including kind of sustainable development. Central, however, is Article 395.4 of the Constitution, which states, to quote, "In the event of doubt about the scope of legal provisions for environmental issues, it is the most favourable interpretation of their effective force for the protection of nature that shall prevail." That's saying that rights of nature should prevail if there is a clash of rights. But of course, you know, these laws have been developed in a highly politicized context, and, you know, there are kind of still many kind of ongoing extractive industries operating in Ecuador. But there have been cases that established a standard that killing any animal that is part of an endangered species constitutes a rights of nature violation. Also cases that have focused on government construction projects, concluding that these projects cannot impede the ability of ecosystems or species to regenerate. The government has also been ordered to control illegal mining under rights of nature case law. These rights have also been enforced in other contexts. So, for example, in 2011, following the government's removal of several shrimp companies from ecological reserves, one company sought to sue the government, arguing that their removal actually infringed their economic interests and their property rights and the right to work. In 2015, the Constitutional Court of Ecuador ruled on this case and said that because natural rights are transversal, so that provision that I mentioned to start with, that they should come first and they impact on all other rights, including property rights. And they said, actually, you know, all of these actions of the state and the individuals must be in accordance with the rights of nature. That was a key kind of moment, because they said, well, actually, sometimes when rights of nature clash with other rights, rights of nature will prevail. So while such approaches could provide key normative inspirations when setting global rights of nature standards, of course, it took a lot of effort in Ecuador to get this ruling. And, you know, there is still a lot of challenge ongoing in Ecuador, as I noted before. In contrast, in New Zealand, the Te Awa Atua Act actually does not derogate from existing private rights in the Wangani River. So the Act states that any actor, public or private, must have particular regard to the interests of the river and must recognise the values of the Maori, which include treating the river as a living entity. So through giving legal personality to nature, but not nature the rights per se in the New Zealand system, it's been set up that decisions on how to balance these rights between ecosystems and you know, the people is actually kind of, and individuals and corporations are still going to have to be made. We don't yet know how that's going to pan out. So, you know, these acts, while they were clearly really important for Maori rights and for the recognition of, you know, Maori jurisprudence in New Zealand, they've been carefully constructed as well to ensure that they actually are framed around the neoliberal legal order and the settler colonial laws of New Zealand. So they, you know, shy far short from saying that the rights of nature should actually, you know, come over and above corporate rights to exploit nature, for example. Another key standard that has emerged in the US in particular is the right of nature to flourish. So not just the rights of nature to be protected, but actually to flourish, to, you know, do well. And this is a very important rights of nature standard, which I think shows much potential. So it's only really been recognized in a couple of US provisions. And again, they're often at the local level. But I think from a post-human perspective on rights of nature, the right to flourish as being part of that framing of the rights of nature is potentially really, really important. So at the same time, we still have a long way to go to set rights of nature in international law. But I think some of the lessons that we can learn from, you know, domestic provisions and from post-human theory can help us think about that. So moving on to kind of some of the potentials and pitfalls of a post-human theory informed rights of nature approach. It's clear that rights of nature and post-human theory align across several vectors. You know, they both seek to recognize the agency of nature and matter, and they both seek to challenge the subject and object binary that underpins Western thought. However, while the inherent links between rights of nature and post-human theory have been suggested, particularly by quite a lot of arts practitioners, for example, from a law perspective, it becomes clear that it's not given that a rights of nature approach will inherently produce a post-human approach to international environmental law if applied there. Because, you know, rights of nature have not really been brought into extensive conversation with post-human theory, and they're still being fought over what they're going to include and exclude. And therefore, from a post-human perspective, there are a few issues here. So the first one I want to draw to your attention is who represents nature. Post-human theory posits that nature has agency, but if the rights of nature are to be upheld at law, humans have to put forward nature's claims on its behalf. Humans can seek to represent nature, drawing on many tools, you know, earth jurisprudence, applying scientific knowledge, but these tools, of course, are never neutral and they do not always provide clear answers. So it's not always clear what is best for nature. But from a post-human perspective, this becomes even more complex. So as Vicky Kirby, for example, has argued, to quote her, she says that to represent nature is to risk reinscribing a humanist anthropocentric blueprint through a human framing of what nature is and wants. So she therefore states that, that nature, and this is the quote, does not need a human scribe to represent itself, to mediate or translate its identity, end quote. Nature is self-organizing, it has its own language, its own networks. So, you know, if the law is to protect nature and nature requires human representation, then that's a problem. And, you know, again, we can kind of see this from multiple different levels. It kind of presents an impossibility, the need to see nature and matter in the law and in our understandings of the world, but our inability to fully understand it. And how do we hold those together? There's something about nature that will always exceed human knowledge. But I think that this does not mean that matter should remain sidelined or objectified, but rather, as Jane Bennett states, there's a need to remain perceptually open. That's a quote from her. To accept that not all can be known, but seek to kind of understand and think about what we can. And Rosie Braidotti offers a similar solution, saying that we need to devise a new vocabulary with new figurations to refer to the elements of our post-human times. So it's kind of about thinking about matter, but also accepting the limits of our understanding is what I'm trying to argue here. You know, even if nature can't be adequately represented, it's probably better to try to do something. There are, of course, then risks presented that in seeking to bring nature into the kind of liberal framework of the law, we end up, and the law is itself so intimately tied to anthropocentrism, individualism, that just adding another subject, it just extends the paradigm without actually changing it. So this is another kind of dilemma here. And we can see this with women's rights. There is an argument that actually international human rights law has accepted women as a subject to some extent, but it hasn't changed necessarily the content of the rights. They just kind of tweaked them to apply a little bit better to women. And this, arguably legitimizes the existing structural formations, which are inherently problematic. But again, I argue that this doesn't mean that we should abandon the Rights of Nature project. I think there's still a lot of promise there. But like feminist international lawyers, there's a need to kind of understand these nuances and to foster change from within a system while seeking to change it from the outside too. Rights of nature were unthinkable a few decades ago, and they're now gaining momentum. And I think there's a need to engage with that. But we also have to recognize the realities of power dynamics here. So, if we're thinking about New Zealand, as I said, arguably that of course is a really important milestone, the recognition of legal personality there and the settler colonial state. But of course, there are limitations, and it's still very much a recognition within that existing settler colonial law. Another problem that we can see is this idea of universalism, thinking particularly about colonialism and global inequalities. So sovereign will and the lack of a universal system for environmental protection are two core challenges facing international environmental law. But if we're looking at, creating a universal rights of nature protection, a global system, well, there are vast problems with the concept of universalism. We know these from feminist and post-colonial theories. We know that universal is never neutral. It always puts forward a particular subject, and it often reproduces gendered and racialized power hierarchies. International environmental law has tried to tackle some of these problems already. So many provisions have been built in to manage this tension. So, for example, the concept of common but differentiated responsibility means that states are kind of supposed to all be responsible, but there's a different responsibility depending on economic development needs of some states. Another example of how this tension is balanced in existing law is the principle of sustainable development, which notes the need to exploit natural resources in a manner that is sustainable and in which economic objectives are taken into consideration to ensure in particular that states with stronger development needs can continue to draw on their natural resources. However, such an approach ultimately does allow for environmental exploitation to continue. And while sustainable development seeks to account for economic imbalances, there are risks presented by such an approach. And Usha Natarajan and Kishan Cody, for example, who are post-colonial international environmental lawyers, note that in the end, sustainable development doesn't challenge ideas of economic growth, and it's seldom used to call for less development. So ultimately, this kind of shows that we need something, rights of nature is good, but there's also a need to challenge existing economic power imbalances. One way to do this could be, of course, the payment of reparations by states that benefited from colonial extraction of natural resources to those they colonized. Probably not very likely to happen, but I think it would be a good thing. The need to challenge global capitalism. But we can also look at theories emerging in environmental law, such as theories of degrowth or the commons. And really what I'm trying to get at here is that these tensions between the aims and the current application of the rights of nature need to be constantly rethought in searching for these kind of international rights of nature standards that I'm looking for. So to conclude the paper, I've argued that there are clear problems with international environmental law, which is essentially anthropocentric, separating human, non-human, and environmental interests into separately demarcated legal spheres, while prioritizing human interests over all others. I've also sought to highlight post-human legal theories challenge to this anthropocentrism, and have tried to argue that those seeking to apply post-human legal theory in practice could benefit by engaging with the rights of nature movement. In turn, I've sought to understand what the rights of nature could learn from post-human theory. But to conclude, and as I've tried to note in the course of my reflections, there are always risks with working within a liberal legal system, that by working within the system and seeking to improve it, one risks legitimizing the system itself. But this is a problem that all critical thinkers face when seeking to apply theory in practice. There's always a risk that a part of the radicality of that thought can be lost in application. But my suggestion here is that, you know, this critical change must occur within the system and outside to be effective. And rights of nature standards and implementing them is, as I've tried to argue, a strong place to start when seeking to reimagine international environmental law in a post-human level. It's essential with all that is now urgently at stake that those seeking to apply post-human legal theory to international law engage with rights of nature approaches, and that in turn the insights of post-human theory are used to contribute to the development of international rights of nature standards and international environmental law. And that's the end of my paper. Thank you very much for listening.
Thank you. Thank you so much, Emily. This was really a fascinating paper, and